California Civil Procedure Handbook rules, selected statutes and cases, and comparative analysis. Chapter 3, pleadings. Subpart C, demurrers. Part 1, general and special demurrers. Page 67. A demurrer presents an objection to a complaint, cross-complaint, or answer when the ground for objection appears on the face of such pleading and from any matter of which the court may take judicial notice. CCP 430.30a, when any ground for objection to a complaint or cross-complaint does not appear on the face of the pleading, the objection may be taken by answer. CCP 440.30b, a party objecting to a complaint or cross-complaint may demur and answer at the same time. Section 430.30c. The grounds for objection to a complaint or cross-complaint are set forth in CCP 430.10, which provides the party against whom a complaint or cross-complaint has been filed may object by demur or answer as provided in Section 430.30 to the pleading on any one or more of the following grounds. A, there is no jurisdiction. The court has no jurisdiction of the subject of the case cause of action, alleged in the pleading. B, the person who filed the pleading does not have the capacity to sue. C, there is another action pending between the same parties on the same cause of action. D, there is a defect or misjoinder of parties. E, the pleading does not state facts sufficient to constitute a cause of action. F, the pleading is uncertain. G, in the action founded upon a contract, it cannot be ascertained from the pleading whether the contract is written, is oral, or is implied by conduct. H, no certificate was filed as required by Section 411.35, malpractice action against architect or engineer. And I, no certificate was filed as required by Section 411.36, association action for negligence against licensed contractor. Notes and questions regarding demurrers. 1. General and specific demurrers. The statutes do not distinguish between general and special demurrers, but courts and attorneys usually do. See 5 Witkin California Procedure Pleading Section 899, 904 through 906, 4th edition, 1997, citing cases. A demurrer on the ground that the pleading does not state facts sufficient to constitute a cause of action, that's 430.10e, is typically referred to as a general demurrer. 1 based on any other ground in CCP 430.10 as a special demurrer. 2. Waiver. A party must demur to a complaint or cross-complaint within 30 days after service and to the answer within 10 days. CCP 430.40. Failure to timely object to a pleading by demur or answer constitutes a waiver of all grounds for objection except an objection that the court lacks subject matter jurisdiction or that pleading does not state the facts sufficient to constitute a cause of action or a defense. CCP 430.80, C. Collins v. Roca, 1972. In which defendant's failure to raise uncertainty of complaint by a timely special demurrer deemed a waiver of such pleading defect. When a demurrer is sustained, the court must state in the order the specific grounds upon which the decision is based. CCP Section 472D. Case note or statute note number 3, standards for general demurrers. A demurrer does not test the truth of the allegations in a pleading, only the legal sufficiency of the pleading. Committee on Children's Television, Inc. v. General Foods Corp. From 1983 in California. The court must assume the truth of all properly pleaded material allegations of the complaint and give it a reasonable interpretation by reading it as a whole and its parts in their context. Phillips v. Desert Hospital District, California, 1989. Consequently, a demurrer must be denied where the factual allegations state a cause of action, but the defendant contests their accuracy. See Committee on Children's Television, Inc., Supra. Defendant's contention that the words and images of their television commercials were not misrepresentations, as plaintiffs had alleged in the complaint, framed a factual issue for resolution by trial, not demurrer. And fourth, case note, or statute note, amendment after sustained demurrer. An order sustaining a demurrer without leave to amend will constitute an abuse of discretion if there is any reasonable possibility that the defects can be cured by an amendment. Cooper v. Leslie Salt Co., 1969, and Goodman v. Kennedy, 1976. To meet the plaintiff's burden of showing abuse of discretion, the plaintiff must show how the complaint can be amended to state a cause of action from Goodman v. Kennedy. This is important to the opposition of demurrer that I wrote recently, and those are cases that didn't come up in that research. We are now moving to subpart D, answers, in the pleadings, chapter 3, and this is only 2 sections, starting with 1, introductory note. A defendant served with a complaint has 3 principal choices. 1, do nothing and risk entry of default and a default judgment. 2, attack the complaint and seek a partial or complete dismissal of the action through use of the demurrer or other related motions. Or 3, respond to the complaint on its own terms through the answer. Conceptually, preparing and filing an answer is the normal procedural response. Whether in practice it is the most common response is not at all clear. The answer is the pleading, just like the complaint, that responds to the allegations in the complaint, except in those few instances when a defendant party can file a general denial according to CCP 430.40a. Answers contain 3 types of responses. First, portions of the complaint which may be admitted, either by express admission or by failure to deny, and 431.30f, 431.20a. Second, allegations in the complaint may be controverted by general or specific denial, 431.30b1, on the basis of information or belief, 431.30d and f, or on the ground of lack of information or belief, 431.30d and e. When the complaint is verified, the answer must also be verified, CCP 446. Third, the answer may provide by stating defenses, usually called affirmative defenses, that provide a defense to the complaint even if its allegations are true. See CCP 430.30b2 and g. Affirmative relief. If the defending party seeks affirmative relief against the party filing the complaint, the defending party must proceed by a separate cross-complaint, CCP section 431.30c, 428.10a, and 428.40. The requirement of a separate cross-complaint differs from the federal practice that combines answers and counterclaims, but not third-party complaints, also called cross-complaints under California law, in the same pleading. If Rules 30 and 14, FRCP, failure to deny constitutes a admission. Every material allegation of a complaint or cross-complaint not controverted in the answer shall, for purposes of the action, be taken as true. CCP 431.20a. Answer. Failure to properly deny a material allegation therefore constitutes an admission, from Valerio versus Andrew Youngquist Construction in 2002. Now, subpart 2 in the answer section, titled Raising New Matter, 4 paragraphs. The answer must contain a statement of any new matter constituting a defense. CCP 431.30b2. Each defense must be separately stated and separately numbered. CCP 430.30g. Rule 2.112, California Rules of Court. Affirmative defenses. New matter constituting a affirmative defense must be stated in the answer. Failure to plead an affirmative defense waives that defense. See, for example, Halsey v. Kohler, of 1990, in which a failure to assert a compulsory cross-complaint in prior action is a special defense, which, like res judicata, if waived, is not raised in the instant action. Minton versus Cavaney of California in 1961, the defendant waived statute of limitations defense by failing to plead that defense in the answer or by demurrer. Excuse me. The reply is not recognized as a pleading in California. CCP 411.10. Consequently, a plaintiff does not reply to affirmative defenses raised in defendant's answer to the complaint. Affirmative defenses are deemed controverted, and a plaintiff may introduce evidence at trial of CCP 431.20b. See, for example, Aerojet General Court versus Superior Court in 1986, where the plaintiff need not answer affirmative defense of statute of limitations raised in defendant's answer in order to contest their defense at trial. And lastly, what constitutes new matter? Under CCP 431.30b2, the answer to a complaint must include a statement of some new matter constituting a defense. The phrase new matter refers to something relied on by a defendant which is not put in issue by the plaintiff. State Farm Municipal Auto Inc. Co. vs. Superior Court 228, blah blah, 1991. Thus, where matters are not responsive to allegations of the complaint, they may be raised. The answer is new matter. Where, however, an answer sets forth facts showing some essential allegation of the complaint is not true, such facts are not new matter, but only a traverse. Example, what is put in issue by a denial is limited to the allegations of the complaint. End of chapter 2.